Hey, so this is all about how to figure out what somebody owned when they died and how to figure that out after the fact. So Paul Rabley here, estate planning attorney. I have handled many estates, many probates or successions. And occasionally after somebody dies, some of the heirs, ask some questions or maybe say something like, well, I thought Dad had some CDs at the bank that aren't in any of the records that we have here. Or I thought he had a savings account at the bank. Not sure which bank it was, but he said he had a savings account. Or I thought Dad owned some shares of stock. Or I thought Dad owned some mutual fund shares. Or I thought for sure Dad owned an annuity. Or maybe they said, I thought Dad owned, he said he had some life insurance. Where can we go to get this information to confirm that he had it? Well, good question. And unfortunately, there's no central registry you can go to after somebody dies and just say, tell me everything that person owned. That central registry doesn't exist. So I like to break it down. Really, there's two ways to get information after somebody died. There's an informal way and there's a formal way. So the informal way to figure out what somebody owned when they died is, check their last few years of tax returns. Every year they'd be getting a tax reporting statement from a financial institution. So if you look at the last 3 years and you don't see anything new, or maybe you see something, a tax reporting statement from a financial institution that you didn't know about, you can inquire there. So checking the tax returns is one way, informal way. Another informal way is check their mail. They're likely getting some type of periodic statement from the insurance company, from the bank, from the credit union, from the company where they may have owned stock. So you can just check their mail, and that's just kind of an informal way to try to track down what somebody owned. Now there's a formal way if you feel like the informal way just doesn't get it done. So the formal way is, let me just give you an example. Let's say Dad, anything that he owned would have been in his name, and let's say he had a will and he named son as the executor. He had a son and 2 daughters. Named son as the executor. So what the son would do, he would open Dad's probate or succession. He would, of course, he'd have to work with attorneys to do this. He would have to get himself confirmed as the executor. And then the courthouse is going to issue what's called certified copies of letters of independent executorship. Well, then son can take those legal documents to all of the banks, all of the credit unions, the brokerage firms, the insurance company, where son thinks Dad might have had an account. And armed with those formal court-produced letters of independent executorship, all those third parties are bound to tell the executor whether an account exists, whether it's a bank account or a safety deposit box or an insurance policy. So that's the way to formally figure out what somebody owned. Takes some legwork, takes some effort, takes some working with attorneys to get the right authorization. Ideally, Dad would have really, documented well what he owned and communicated that with his children before he died, so there wouldn't be all these questions after he died that would take months, maybe years to resolve, and significant expense. So that's the deal on trying to figure out what somebody owned when they died. And there's different inquiries to different people, whether it's a financial account or whether it's real estate or a vehicle. There's different people to ask and different ways to inquire based on the underlying asset that may have existed. So hope that helps getting an estate settled. If you do it right, it can be somewhat efficient. If there's a blip, then it can go on for a long time and really frustrate the heck out of everybody. So hope this helps. Have a great day.